Prosecutors and cops are sworn to protect and uphold the law and follow the rules. Every year, there are hundreds of cases of prosecutorial misconduct, false arrest, and wrongful convictions that can happen in our justice system. Some prosecutors, police officials, and politicians with personal agendas call press conferences to launch inflammatory and usually false or grossly exaggerated claims about the importance of a given case, totally ignoring the facts in a rush to judgment. Examples are legion. Although the goal of every justice system is to provide fair and impartial judgments, more often than not, it doesn't work out that way. Either because of concealed evidence, people being framed, or corrupt law enforcement. Prosecutors are the most powerful players in the American criminal justice system. Their decisions, like whom to charge with a crime and what sentences to seek, have profound consequences. So why is it so hard to keep them from breaking the law or violating the Constitution? The short answer is that they are almost never held accountable for misconduct, even when it results in wrongful convictions. It's time for a new approach to ending this behavior. Federal oversight of prosecutors' offices that repeatedly ignore defendants' legal and constitutional rights. There is a successful model for this in the Justice Department's monitoring of police departments with histories of misconduct. Among the most serious prosecutorial violations is the withholding of evidence that could help a defendant prove his or her innocence or get a reduced sentence, a practice so widespread that one federal judge called it an epidemic. Under the 1963 landmark Supreme Court case Brady versus Maryland, prosecutors are required to turn over any exculpatory evidence to a defendant that could materially affect a verdict or sentence. Yet in many district attorneys' offices, the Brady rule is considered nothing more than a suggestion, with prosecutors routinely holding back such evidence to win their cases. State courts often fail to hold prosecutors accountable, even when their wrongdoing is clear. And individual prosecutors are protected from civil lawsuits while criminal punishment is virtually unheard of. Money damages levied against a prosecutor's office could deter some misconduct, but the Supreme Court has made it extremely difficult for wrongfully convicted citizens to win such claims. This maddening situation has long resisted a solution. What would make good sense is to have the federal government step in to monitor some of the worst actors, increasing the chance of catching misconduct before it ruins people's lives. The Justice Department is already authorized to do this by a 1994 federal law prohibiting any pattern or practice of conduct by law enforcement officers that deprives a person of legal or constitutional rights. The department has used this power to monitor police departments in Los Angeles, New Orleans, Detroit, and Seattle, among other municipalities, with a history of brutality, wrongful arrest, shootings of unarmed citizens, and other illegal or unconstitutional practices. For the most part, the results have been positive. Since prosecutors are also law enforcement officers, there is no reason they and their offices should be immune from federal oversight. In this insider exclusive network TV special, Justice in America, Roy Pena's Story, we visit with Ron Podboy, who successfully represented Roy Pena when he was wrongfully accused of attempted murder and first-degree assault, which a jury later found him not guilty. Ron is a former deputy district attorney in Denver, Colorado, as well as an experienced criminal defense trial lawyer. And he's seen and knows both sides of the law and will discuss prosecutorial and police misconduct, qualified and limited immunity to police and prosecutors. What legal option do you have after having been accused and prosecuted for a crime you did not commit? What if you are falsely accused? What not to do? So let's assume that you are accused. What do you do? And equally important, what do you not do? And how to protect yourself and your family. Remember, it doesn't matter if the accusations are a lie. Cops and prosecutors lie all the time. And bad cops and bad prosecutors don't care if you are innocent or guilty. They've already decided you're guilty. And they don't care about the truth. So don't assume the people in the system will be fair. Americans like to believe that this is a country where fairness and justice reign. That's nonsense. But most people don't discover just how bad things are until they are charged with something they did not do. These falsely accused victims could be you or me one day. And if you are so unlucky, you will quickly find out that justice in America is a hard-won battle where very few police departments, law enforcement agencies, prosecuting attorneys, and prison officials do the right thing when they are wrong. And you need an experienced and passionate trial lawyer like Ron Podboy, who has successfully fought these battles to get his clients the justice they deserve. Ron has earned the highest respect from citizens and judges alike as one of the best criminal defense and civil rights trial lawyers in Denver and in Colorado. He has seen many innocent and hardworking people become victims of false accusations, false arrests, and false imprisonment. And because of that, he is driven to fight for people who have been harmed by the willful or negligent actions of others. He's built a substantial reputation by consistently winning cases other law firms have turned down. And his amazing courtroom skills and headline-grabbing success rate continue to provide his clients with the results they need and the results they deserve. This is the Insider Exclusive, live from Denver, Colorado. It is my great pleasure to introduce, once again, Ron Podboy. Welcome to the show, Ron.
Thank you, Steve.
Tell our audience a little bit about your law firm, what type of practice you do.
Steve, I'm a solo practitioner. I have very good support, and that's important for any solo practitioner. My firm is mostly handling criminal defense. I cut my teeth in the courtroom as a prosecutor for 8 years. I love the criminal law, and that's what I do mostly. However, I like to enter the courtroom from different doors. I also do civil cases. I've done employment law, which in Colorado is hard to prosecute as a plaintiff because of very protective case law for companies, also personal injury, also wrongful death. But you know, if it's all about talking to a jury, I like to do it.
Today we're going to be talking about a criminal case that you handled successfully for a client by the name of Roy Pena. Considering the fact that you spent almost 8 years in the Denver District Attorney's Office, you've seen how they work. And for the last, how many years now, maybe 35 years, you've spent on the other side of the bench where you are representing people who have been alleged to have committed crimes. What would you say, before we get into the case, what would you say this is a case of?
Well, don't make me too old. I'm not 35 plus 8 professionally. I practiced a total of, I don't know, something like 33, 34 years. Now, the first 8 years were in prosecution. This case was really about a guy getting caught in the crosshairs where a detective badly wanted to make a case, skewed the evidence so that it looked like my guy was guilty. The prosecutor was a young prosecutor. He didn't do what a really good prosecutor should do, which is rigorously analyze the evidence from as dispassionate an attitude as you can. He just picked up what was presented to him by the detective, ran with it. Wrong thing to do. I've had other cases when I was a prosecutor that woke me up to that. I had a case where the detectives who put together the case were betting against me because I told them they had the wrong guy on a murder case. It turned out to be right. And in these cases, very often, physical demonstrations can be really important in the courtroom to show how somebody was stabbed, from what angle. And that was a case that, this was a case with Pena that bore that out.
Yeah, one of the negative aspects of being wrongfully charged, overcharged, a prosecutor not doing his job, is that a person, the defendant, the one you represent, their life almost is destroyed, right? Because in the headlines it says things that aren't true, and it costs them money to defend themselves. That money being never recovered against the prosecutor's office or the police department that wrongfully charged them, right?
That's true. And, in this case, because it was an attempt, there were two charges, attempted murder and first-degree assault. The attempted murder could carry, 24 to 48. The assault, 12 to 24. Those could, if he was guilty on both, the judge could stack that. That means his life's over. But during the pendency of the case, he was given a $100,000 bond. He couldn't make a $100,000 bond. The family needed to take money to secure a defense attorney. So he sat in jail for a year before he was tried.
And he is never going to recover that year in his life.
That's gone.
So let's talk about Roy Pena. Who was he? Who is he?
He worked for his brother. His brother had a security service called, they called it SAS, S-A-S-S. And Roy worked regularly at the nightclub El Chaparral in Adams County, Colorado, where this event happened.
Never been in trouble before.
He'd never been in trouble before.
What happened? Why did this case happen?
At nightclubs sometimes there's animosity or hostility between groups. That's what happened this evening. And Roy could see it coming. I mean, I think they knew he was a security guard there regularly. He was off duty. And there were stares and looks all evening between the two groups. The group that Roy was with, which included some of his friends, some of whom were also off-duty security guards, and Sosa Favela's group, which were, a bunch of guys out drinking that night.
They went outside. Things escalated.
After last call for alcohol, everybody's going outside. Sosa Favela and his group. Sosa Favela was a big guy, big 300-pound guy. He was out there as soon as Roy Pena came out. He started in with the words. It wasn't long before it became physical.
And what exactly happened?
They get into a tussle. Roy gets in a quick and good punch against Sosa Favela, drops him, okay? It was a melee. Roy had no weapon. What he did was punch to defend himself. But as it became clear later, one of Sosa Favela's cohorts, either a guy named Calderon or Sinaloa, had a screwdriver. Two people were injured with that screwdriver. One was a friend named Garcia, a friend of Roy Pena's. He had a scratch on him, which we certainly believe was caused by that screwdriver. And in the melee, it became clear that it was either Calderon or Sinaloa who had that screwdriver who ended up punching into Sosa Favela,
his friend,
in the melee, and that screwdriver was found out later, punched into the heart sac. Did not penetrate the heart, but when there's an incursion into the heart sac, of course, that can be fatal.
Now, Roy went to the back of his truck, correct?
After the first melee.
Yeah, he got a taser, right?
Yes, he did.
Let's talk about tasers. Are you allowed to, as a private individual, allowed to own a taser?
I think you can own a taser, but certainly in that circumstance, he was probably out of bounds getting that taser.
Most tasers that I've seen are painted yellow, right? The ones that the police...
This was orange and black, this one.
Orange and black. They're distinct color from a revolver, which is usually black.
Yeah.
He brought that taser in the course of the melee, right? And that's one of the reasons he was charged with a third charge, wasn't he?
He was found he wasn't charged with that, but he was, in the jury instructions, they included felony menacing, okay, as a lesser charge, and that's what he was found guilty of. Because yes, he went back to the truck, he got his taser. When he came back, he never got within 5-6 feet of Sosa Favela again. He did hold the taser on him, okay? Now, that was how that came into consideration by the jury, because it was fair to say it was nighttime. It was what, 2 o'clock at night on December 6, 2011. He was holding what appeared to be a gun, or fairly would have appeared in the dark to be a gun. Now, the law under felony menacing is if you're holding a weapon that can put someone in fear of their life, whether or not it's a real weapon, if that's their perception, okay, and fairly that was the perception. So probably a fair verdict by this jury, because, yeah, he admitted that's exactly what he did. But he didn't injure anyone with that.
So that applies to someone who holds a water pistol that looks like the real thing.
Yeah, or even a child's gun. You remember, what was his name? Tamir Rice in Ohio. This was a kid who had a child's toy, which was a reasonable facsimile of a gun. Here's a cop who hops out. Oh, it's a gun. Boom. He shot within 2 seconds. So, yeah, it's the perception of the person who can argue they are threatened.
Sosa Favela ended up going to the hospital. He did not die. Because he got quick medical attention.
Very good attention at the trauma center at Denver General.
But then the case developed. So take us from there.
He made statements. And of course, this animosity against Roy Pena, he exaggerated things. He made up stories. He also didn't describe accurately the fight. He put himself in a good position as an innocent person, ostensibly, and that Pena was the aggressor the whole time. This wasn't the case. But as things developed in this case, well, let me go on and talk about the fact that Pena, shortly after, now there came the arrest warrant for Pena. He had no idea there was an arrest warrant. He's going down to visit his parents, who are Mexicans. He goes across the border for half a day. He comes back. He's arrested because that arrest warrant is on NCIC, and they arrest him at the border, extradite him back to Colorado, where he's interviewed, okay? Roy Pena was an American citizen. The prosecutor wanted to paint this as running from the crime, guilty knowledge associated with running. So that was one of the big motions in the case. In addition, the other big motion in the case, which I had to deal with forcefully, was the detective who interviewed him, who, one, violated his Miranda versus Arizona rights, and two, misinterpreted in order to make it look like he was confessing. And by misinterpretation, it was because Roy is listening to him and going like this, and he's saying, oh yeah, he's nodding, therefore he's confessing, yes, I did all this. That wasn't the case at all.
When you had that detective in the courtroom, you asked him specifically, why did he think that Pena was guilty of all these charges that he was charged with?
And that's where his prejudice, his clear prejudice, came to the fore, because he quickly responded, he's guilty. I've been doing this for 16 years, and I just know it.
How does that resonate with the jury?
It didn't resonate with this jury, because they walked Roy Pena on the attempted murder, also on the first-degree assault. He simply didn't do what it was alleged that he had done.
Well, congratulations on basically getting him off charges that he should not have ever been charged.
This is really what defense attorneys call the worst type of client. And the reason that we say that is, the more I looked into this case, the more I was entirely satisfied that he was not guilty. In that case, he's being offered pleas that, okay, just go to jail for 12 years, just go to jail for 16 years. He was a man who was not guilty. He said, I'm not taking any deal. This must be a trial. That means, as a defense attorney, I must do my job well, and I must walk him out of that courtroom because I'm defending somebody who is not guilty.
I think you mentioned in the summary of the case, you build on the lie.
I call it concentrating on the lie.
What's that mean?
Sosa Valvela was on the stand. I grilled him thoroughly. I knew he was lying. I knew he was lying about pants off in the nightclub. I knew he was lying about the aggression of Roy Pena. I knew he was lying about Pena having a sharp weapon that could have hurt him. I knew he was lying about the description of physical placement of the players. So when you concentrate on the lie, you take your mortar and pestle and you grind that lie down. Lies don't hold up in the courtroom. And that's exactly what happened here. It became clear to the jury that he was not presenting truthful testimony. It became clear that he was presenting a biased story in order to get Roy Pena charged. Now, I've seen this many times where someone is badly injured in some altercation. If the story comes from the injured party or his party, the prosecutor wants to believe, yeah, it was the other guy who did it, even though that may not be true. Because, gee, it's serious injury. Let's get a conviction here.
Yeah, one of the reasons we do these shows is because a lot of people who are unfamiliar with the legal system all of a sudden find themselves charged with a crime.
Sure can happen.
They automatically think, well, I'm innocent, the truth is going to come out, the truth is going to set me free, but that doesn't work in many cases.
You know, I had a prosecutor one time in a case in cross-examination asking the case, and I was defense counsel, gosh, why didn't you, if that was true, why didn't you go tell the police? You know what? The police are often biased in order to create a particular scenario that leads to guilt for someone who is charged. The naive assumption that the police are a neutral or performing neutral analysis can really bite you.
Yeah, so we've talked about sometimes prosecutors are not neutral and interested solely in the truth. We've talked about the police, same thing. Let's talk about judges. And let's talk about the judge in this case and what happened to you.
She was a judge who was, some judges are very comfortable in the power that the office affords them. She was a judge who was nervous, if you will, or unsure about her power, so she tended to push it. It was incumbent on me to bring that taser into the courtroom. It was part of the case, but I had to check it at security. They said, get it from the sheriff up in the courtroom. I asked the chief sheriff, and as it happened to be, brought it out. I asked him for the taser. He has it there. He goes, do you have the battery to this taser? I said, no, I don't. He said, can you make the taser operate? I said, no, I can't. Then he again asked me if I have the battery. And at that point, I got smart and I said, what part of no don't you understand? Okay, he takes that story back to the judge. On the record with the jury, outside of the hearing of the jury, she accuses me of being disrespectful to the court. I took the podium and I challenged her on that directly, said, I have never been disrespectful to the court. Go back through the transcript of this case. Show me where I've been disrespectful. I am always respectful to the court. However, the sheriff is not the court. And I did give him that answer, but it showed his repeated refusal to believe me, showed his bias, and by the court taking up his position, the court is evidencing bias against me, which must redound to my client. You need to recuse yourself right now and set this case on another judge's docket. Her response to that was to look down. I think she knew what I was saying was true. She looked down and then looked up and said, let's proceed with the case. Never mentioned the incident again.
But that is on the record, though.
That's on the record. There's another thing that was happening an atmospheric, if you will, in the courtroom with that sheriff's department. They were running everybody who was in the family. They were running criminal histories. The older brother of Roy, named Jesus, someone had used his name in a traffic stop and he had a warrant on him, unbeknownst to him. They arrest him. Took 2 days to straighten out.
In the courtroom.
They arrested him in the courtroom, walked him right out. Another brother violated a court order by using a phone in the courtroom. Arrested, taken right out.
And who ordered the arrest? The judge?
Well, the judge had given the order. The sheriff saw the violation. The sheriff arrested because they had heard the order and they saw it was a violation.
How does that happen? The trial's going on. He sees one of the relatives using a phone. Does he make a motion to the court? How does he do this?
It effected the arrest at a break and explained to the judge what was going on. We saw a violation of your court order, Judge. He's under arrest. So, I'm trying to remember if that relative was allowed back in the courtroom. But the sheriff was putting as much pressure on the family also associated with this case just to make it hard on him. The sheriff even came over to me and said, "They're dropping like flies," kind of to goad me. But through different training, I am laser focused in that situation. That bounces off me. I keep my eye on the prize and don't react to comments like that from a sheriff or anybody else.
Right. End result, he was charged with 3 crimes. What were they?
Well, he was charged with 2. Attempted murder, first-degree assault. A lesser included in the jury instructions was the felony menacing. That was what he was found guilty of. The jury walked him not guilty on attempted murder, not guilty on first-degree assault. They knew he didn't do it. But he had admitted holding that taser on Sosa Favela. It could be interpreted as a deadly weapon, particularly at night. And, as I put it in the materials that I gave you, I can't say that wasn't a fair verdict. And at sentencing, Roy Pena got probation. Again, fair off of that verdict.
He had already spent 1 year in jail, though.
He'd already spent 1 year in jail.
Okay. A Class 3 felony, what does that restrict him or prohibit him from doing in the state of Colorado? Can he own a weapon?
No, certainly not as a convicted felon. And a felony menacing, it's a Class 5 felony in Colorado. He's guilty of that. So as someone who has suffered a felony conviction, no, you can't carry a firearm. So he's knocked out of the security business.
Okay, oftentimes when people are arrested, first of all, they're scared to death. Many times they've never been in trouble before. Sure. So law enforcement comes, they arrest them, they bring them to a jail, and maybe they bring them, we all see it on TV and the movies, they bring them into an interview room. And a lot of people, think, as I said in the beginning of this show, that, hey, I have nothing to hide, I'll tell you everything you want to know. Why is that the absolute wrong thing to do?
We've already talked about bias that an investigator can have. They want to close a case. They want to charge somebody. They want to skew things so that happens. And just sitting there like, oh, gee, I know the truth. I know I'm not guilty. That you can be walking right into a ditch with that attitude.
They can take your words as they did in Pena's case and say you confessed.
Number one, he indicated he wanted a lawyer. Under our Miranda law, when you say that, the questioning's over. He said that, and it wasn't more than a few minutes later the detective started to interview him again. Can't do that, okay? So that was one motion in court that I brought. The other thing was that the detective said, well, I explained what was going on. Pena asked, what can I get for these charges? The detective was explaining the charges, the possible penalties. Pena's sitting there nodding his head like this, understanding what those penalties are. And the detective says, oh, nodding his head was his admission to the crime. Now, I can be sitting here looking at you, Steve, and thinking to myself, that's Steve Murphy. He's a talented interviewer. I think he's one of the best I've ever bumped into. Or I can be looking at you the same way and thinking, Steve Murphy doesn't know what he's doing. He's faking it through this whole thing. You don't know what I'm thinking. and I can be sitting there nodding or giving you whatever body motion, and you don't know what my inner thought is. This detective was saying, I can read his mind.
The one message, a very important message among many in this show, that I want to send out, and please confirm this, is that police officers, when they interview you, they are allowed to lie to you. Yes or no?
Well, that's true. They can tell you, they can say, well, maybe you've been charged with a friend of yours, or the other friend is being interviewed. They can say, Bob Jones is in the other room. Guess what he told us? He told us you did it. They're saying this in order to solicit a reaction from you, which they hope will be beneficial to a case against you. All right, it doesn't have to be true. But if you lie to the cops, you lie to the FBI, you lie to the local cops, it's a crime whenever you do that.
So let's talk about, you have represented many people in unfortunate criminal proceedings. Tell people what they should not do, absolutely, when they get arrested.
Don't build a case against yourself. Say I want a lawyer, and that's that. Repeatedly. I've had a situation where I got a phone call about someone being investigated on a certain style of sexual assault. The detective had contacted this person, said, be down here at 10 o'clock, talk to me. That person called me, hired me. I told the detective, you're not interviewing him. If you have a case, file it. He didn't file it. There was no case. What this detective was trying to do was get enough information out of this individual to say, oh, you fit A, B, C, and D. We're going to assume E, and that's the 5 elements we need. So as for an attorney, everybody has a right to an attorney, whether you can pay for it or not. Thank goodness, in the good old USA.
Another point I want to get across is don't assume, like we talked earlier, that the system is fair.
That's true. Everybody has an interest. That's why they call it an adversarial system. There are adversaries in the courtroom. Necessarily, one side is advocating one position, one side is advocating the other position. Sometimes the truth is in the middle. Sometimes it's entirely with the prosecution. Sometimes it's entirely with the defense. That's what a jury is for, to figure that out.
One last question. You have a lot of people call you up, you're well known here in Denver, and they say, I got a problem, come on in, you interview them. How do you select the cases that you do?
Everybody needs a defense. I will defend even very difficult cases that you go, oh my gosh, they did that. How can you defend that person? And that's the sophomoric question I've gotten from so many people. Look, when I'm acting as a defense attorney, even if this person is guilty, I want to look carefully into the facts, look carefully into their background, and try to work out something which is overall fair for the case, which doesn't allow an overweening prosecution, which doesn't allow it to happen where someone who may be a victim says, what's the maximum? That's what I want in this case, because a victim is so often going to say that. So very often in negotiating a case, and many clients are guilty, what you're trying to do is get the most fair result in that case.
I want to thank you for being on the show.
Glad to be interviewed by you, go over these concepts. I think they're so important because, frankly, nobody knows when they're going to be stopped. Nobody knows when they're going to be charged, rightfully or wrongfully. It's always good to see you, Steve.
Thanks for joining us. You can get more information about our guest and the issues at insiderexclusive.com.